Joining us now are my colleagues Paul Saunders and Patrick Haynes. Paul serves as Williams Mullen's ethics counsel, as well as offering ethics advice and counsel to clients outside the law firm. Paul also focuses his practice on a range of corporate matters, including secondary mortgage, market purchase and sale and securitization transactions, trust preferred security transactions, project finance transactions, including PERPA, qualifying facilities, and exempt wholesale generators. Patrick is a member of the litigation section and serves as co-chair of the white collar and investigations team. He focuses his practice on handling all matters of disputes that arise from business competition and regulation. His practice has included a broad base of civil and criminal litigation at both the trial and appellate levels. He also acts as deputy counsel for the firm. Welcome, Paul and Patrick.
Thanks, Farhad.
Thank you. Welcome to everyone for an hour of ethics right after lunch on a Friday, but we'll try to make it as entertaining as we can. And let's just kick it right off with our first of our case scenarios today. Delta Company is one of a number of wholly owned affiliates of Alpha Company, the holding company of Delta, and of other affiliates within the family group. You are an in-house patent lawyer employed by Alpha. Delta requires legal advice concerning patent infringement with respect to certain patents held by third parties. So our first question today, first polling question is, may you perform legal services for Delta with Alpha's consent? So we're going to open up the poll here. May you perform legal services for Delta with the consent of your employer, Alpha? So we're going to leave this open for, I think as before, you'll be familiar, we leave it open for about 30 seconds to give people a chance to vote. Don't forget that you have to vote for each on each question that we have in order to get your CLE credit. We have a little bit more time for the polling. You can imagine the Jeopardy music in your head if you'd like to pass the time more quickly. I think it's probably been enough time. Let's get the results. So 81% of you answer yes, you may perform legal services for Delta with Alpha's consent. Paul, what is the answer?
And the answers have it. First, as a matter of background, the in-house legal staff at any corporation isn't automatically considered to represent all of the corporation's subsidiaries and affiliates, which can create issues concerning the identity of your client. There's a comment to Virginia Rule of Professional Conduct 1.10, which sometimes known as the imputation rule. And it notes that a firm includes, quote, a legal department of a corporation or other organization. The comment goes on to state, it may not be clear whether the law department of a corporation represents a subsidiary or an affiliated corporation, as well as the corporation by which the members of the department are directly employed. So the identity of Delta as your client and its relationship to your employer, Alpha, should be described and documented. I would suggest it would make sense as a general matter to have done that up front and not do it on an ad hoc basis as issues come up. Now, this particular situation was analyzed in Virginia Legal Ethics Opinion 1838 several years ago. Begin with the general proposition that a lay corporation, that is, a corporation other than a law firm, cannot employ a lawyer to represent third parties. That would involve the corporation in the practice of law, and since it is not a law firm, the corporation could not do so. It would be UPL. The opinion concedes that you should be able to provide legal services to your affiliate Delta, so long as you provide them directly to Delta, independently and without any conflicts of interest, and with the consent of your employer, Alpha Company. And when a lawyer performs legal services for one party at the request of another party, the identity of the client must be clear at all times, as the lawyer owes the client a duty of undivided loyalty and confidentiality. Now, assuredly, the interests of Alpha and its affiliate Delta may well be identical, but you owe both of them a duty of undivided loyalty and the exercise of independent professional judgment. So communications between you and Delta must be direct and not shared with Alpha without Delta's consent. Confidences of Alpha acquired during the representation must be held inviolate. The opinion even suggests that to protect the confidentiality of Delta's information, you might have to perform work for Delta at a separate office rather than on the premises of Alpha. I got to say, the opinion has, it seems to me, an air of unreality about it. When I've talked about these issues with in-house counsel, the first question that comes up is, how in the world can there be a conflict between a corporation and its wholly owned subsidiary? How can their interests become so misaligned, if you will, that it creates a conflict of interest? Certainly, if that happens, you should think that in a well-run organization, that conflict would exist only so long as it took for the parent to fire the individual or individuals at the subsidiary who were creating that misalignment. We had an example in Richmond some years ago involving a very public spat between the head of a large investor-owned utility and the head of the utilities holding company. Now, in that case, I suspect that the holding company head wanted to terminate the head of the utility, but as the utility was regulated by a host of entities, and most especially the State Corporation Commission, the State Corporation Commission basically blocked that path by announcing that it and it alone had jurisdiction over who the executive officers were of a utility that it regulated. Eventually, they worked that out, but you could see how with a regulated subsidiary and an unregulated parent, personal differences or other differences between the boards of each could result in a misalignment of interests and create a potential conflict for a lawyer who, while an employee of one, purported to represent or was directed to represent the other. I think that kind of misalignment can arise with respect to other regulated industries. Banking comes to mind, although I can't think of an instance in which the head of the holding company got crossways with the head of a bank that was its wholly owned subsidiary, but it seems to me there is a potential for that. In addition, I think there are sometimes occasions, and what comes to mind is GE and GE Capital when it was a GE subsidiary, where the subsidiary grows so big that I don't know that GE Capital was big enough to dwarf the rest of GE and its affiliates, but it was probably of a size that was at least comparable. And that can lead to issues between the two, giving rise to a conflict. But I've got to say, in the ordinary course of handling day-to-day legal issues, I don't think that these conflicts would ever come up for most in-house counsel.
And Paul, just as a part of a follow-up on that, and you had mentioned earlier that you can have this as a pre-existing arrangement already documented between the parent company and its affiliates and subsidiaries. And you could cover in that the information that you gain from one will be shared with the parent, could you not?
Yes, you could. It seems to me the only limitation on that might be considerations regarding preservation of the privilege. You would want to limit the communication of privileged information to the extent necessary to prevent waiver.
Mhm. Yeah, either that or also memorialize a common interest, perhaps.
Or a common interest agreement. That's right.
Okay, well, what about the fees? What about the cost of your in-house lawyer?
Interesting issue. According to the opinion, Alpha can recoup its fees allocated to your services for Delta. But the fee must be no more than reimbursement for the actual cost of the legal work performed by the lawyer. Actual costs can include costs that the corporation incurs to employ the lawyer based upon the services provided. But in this case, Alpha couldn't make any direct or indirect profit off of your services for Delta. That would be considered fee splitting.
Okay. So, but some pro rata portion of your salary could be shifted from the books of one to the other.
That's right.
Okay. All right. Thank you. All right. Well, let's go to the next slide. Case 2. All right. We're here, Paul. We're assuming the same facts as case 1 are Alpha and Delta Company. Delta Company is headquartered in California, where it also has several hundred of its employees. The work you will be performing, this patent infringement analysis, will require your physical presence at the Delta facility in California on a regular and for more or less continuous basis for at least several months for you to gather information, consult with Delta's management and its many technical personnel about the complicated issues, technical and otherwise, regarding the scope of these patents. You are, of course, an active member in good standing of the bar in the state where Alpha is located and where you reside, where you currently reside, but you are not a member of the California bar. So the question for our next poll is, may you perform these legal services without becoming a member of the California bar? So we are opening up the question, ethics 2, may you, ethics question case number 2, may you perform these legal services without becoming a member of the California bar? Yes or no? We'll give some time to answer that. 30 seconds left. All right, the vote is closed, and 76% of you say yes, you may perform these legal services without becoming a member of the California bar. Paul, what is the answer?
The answer is yes, but you have to meet certain registration requirements with the state of California. Might want to bring your surfboard too. Doesn't mean you have to surf, just stick it out the back window of a convertible you lease. That always worked for my high school classmates in Virginia Beach. The issue arises under the rules governing the unauthorized practice of law, or UPL. It's not just an issue for non-lawyers. UPL issues apply to lawyers who practice in jurisdictions where they're not licensed or otherwise authorized to practice. The ABA model rule, which is 5.5, and most states have adopted it with some variations, mandates that a lawyer not admitted to practice law in a jurisdiction shall not, except as authorized by the rules or other law, establish or maintain a resident office or other systematic or continuous presence in the jurisdiction for the practice of law, or hold out to the public or otherwise represent that he is admitted to practice law in that jurisdiction. Now, in California, there's a rule of the California court rules, as 9.46, will permit you to work there as in-house corporate counsel for a qualifying institution. In this case, Delta would qualify. so long as you register with the State Bar of California. Now, that rule requires that you be an active licensee in good standing of the bar of a state of the United States or jurisdiction, possession, territory, or dependency of the U.S., that you abide by California's laws and ethics rules, that you practice exclusively for Delta, except for pro bono services permitted through eligible legal aid organizations, and that you reside in California when you're providing these services. Lawyers who qualify under that exception don't have to sit for the California bar exam, which would be a relief to me, I know, as its pass rates are typically the lowest in the nation. But they do have to submit to the state bar's moral character determination as part of the registration process. If your application of moral character is approved and your application granted, you must renew your registration annually, and you must satisfy California's MCLE requirements. The requirement to register in order to provide in-house legal services in a particular state isn't just a California quirk. According to a website maintained by the Association of Corporate Counsel, as of 2017, only half of the states do not require any form of in-house licensing or registration. Many, if not most, of the rest require some sort of registration. So it's important that you consult the rules of any jurisdiction where you may be assigned to a particular subsidiary or affiliate to provide legal services on a continuous or regular basis. Do that first.
Yeah, Paul, and let me ask a couple of questions that have come up in the Q&A, just very quickly. First of all, one question that we were asked was whether this would that would be true for certain law, but how does this registration apply for patent law, since the patent lawyer must be licensed by the USPTO and that his work would arguably be solely federal. One, I'll go ahead and answer a little bit about this because it connects to what you just said. It's really important to look at each state's rules. For example, in Virginia, its UPL rule, which I was just looking at recently in its rule and its LEO regarding out-of-state lawyers, would permit a person to be in Virginia if they were providing solely, federal law related advice. One catch to that can be that certainly certain claims could be made potentially under state laws. So you have to look really carefully at that. But you also have to look at what the specific state's rules would exempt from the out-of-state coverage. Another question, though, that's interesting based on case one, which is, does the reverse situation have the same result? Can an in-house counsel for Delta represent Alpha with Delta's consent? And I
think the answer is clearly yes. It isn't derived, or the opinion wasn't based on the fact that the lawyer was employed by the parent and was providing representation to the subsidiary. I think it would work in reverse just as well.
I think you're right. Elizabeth, if you can go back to the previous screen, we actually hadn't begun case 3 yet. All right. So nobody look and nobody cheat on the question for case 3. Because we're all lawyers and we're all honest. The issue here is that you have joined the in-house legal staff at Pharmaco, a large drugstore retail chain. And last year, another lawyer withdrew from the in-house legal staff at Pharmaco and joined a large law firm. You just learned that this large law firm has, for the past 2 years, represented a company in the assertion of a breach of warranty claim against Pharmaco over asbestos contamination at a property that Pharmaco sold to this company. You also learned that the lawyer who left Pharmaco last year to join the buyer's law firm handled the sale of the property for Pharmaco. But that lawyer does not appear to be personally involved in the law firm's representation of the buyer. Now, the question here is, does the law firm nonetheless have a conflict of interest in handling the claim against your employer, Pharmaco? So we will, this question is open. Does the law firm have a conflict of interest in handling the claim against Pharmaco because the lawyer who withdrew from Pharmaco and handled the sale of the property left Pharmaco and is working for the law firm? A few more seconds. All right, we close this one. 78% say that the law firm does have a conflict of interest in handling the claim against Pharmaco. Paul, what is the answer?
And the majority has the correct answer. The answer is yes. Law firm does have a conflict. This involves an application of Rule 1.9, which deals with conflicts with former clients. It provides basically that a lawyer who formerly represented a client in a matter can't represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless both clients consent after consultation. Consent after consultation is a term of art. It really means that the lawyer, in requesting the consent, has provided sufficient information to each of the parties so that they appreciate both the conflict and the consequences of waiver, something called informed consent. Now, the first question or first issue you need to deal with in these cases is whether the lawyer who left the in-house legal department at Pharmaco, quote unquote, formerly represented Pharmaco in the matter of the sale of the property to the buyer. There's an ABA formal opinion from 1999 that says direct involvement in a matter or a style of supervision that results in access to material information concerning a matter must be shown in order to establish that the formerly employed lawyer represented the organization in a specific matter. Now, under the facts, as we've established this hypothetical, it could only be concluded that the lawyer was directly involved in the negotiation of the warranty that is at issue in the buyer's claims, and therefore did formally represent Pharmaco in the matter of the sale. The second question is whether the real estate purchase and sale transaction in which Pharmaco sold the property to the buyer is substantially related to the breach of warranty claim against Pharmaco. Now, comment 3 to Rule 1.9 provides color to this concept of substantially related. Matters are substantially related if they involve the same transaction or legal dispute, or if there otherwise is a substantial risk that information as would normally have been obtained in the prior representation would materially advance the client's position in the subsequent matter. The drafters of the rule, and this language is taken directly from 1.9 of the model rules, were concerned that the former client shouldn't be put to the task of disclosing the information that it was trying to keep confidential and that it claimed was being misused by their former employee lawyer. So they came up with the concept of substantial relatedness. If the two matters are substantially related to each other, then essentially Rule 1.9 assumes that the lawyer acquired confidential information in the prior representation that would be material to his representation of the second client and therefore would disqualify him. Instead of requiring the former client to disclose, then you have the substantial relationship task as a kind of proxy. The reps and warranties that Pharmaco made in the sale of the property were negotiated by the former in-house lawyer and would be a central issue in the breach of warranty claim against Pharmaco. So it seems to me clear that the two matters are substantially related. Final issue to be resolved is whether the law firm has a conflict, even when the lawyer who left Pharmaco is not personally involved in the firm's representation of the buyer. Rule 1.10, the imputation rule, says that while lawyers are associated in a firm, none of them shall represent a client when the lawyer knows or reasonably should know that any of them practicing alone would be prohibited from doing so by Rule 1.6, the confidentiality rule, or Rules 1.7, 1.9, or 2.10E. So the conflict, in a sense, follows the lawyer to the law firm and would be imputed to all of the lawyers working on the buyer's matter. Those of you who might wonder whether a screen would work here, a unilateral decision by the law firm to screen off the former Pharmaco lawyer from those involved in the buyer's claim won't work. The only way for the law firm to avoid disqualification is to seek and obtain waivers from both buyer and Pharmaco, waiving the conflict, probably containing a condition that the former Pharmaco lawyer be screened from participation in the representation of the buyer and from sharing information she gained during her prior representation of the company.
Now, Paul, I noticed that in the ABA opinion that the ABA actually speculated in certain circumstances here, Pharmaco may have an interest in granting its consent. That may be wishful thinking, I think, for a lot of us in this scenario, but maybe can you explain what they may have meant by that?
Well, their suggestion is that Pharmaco might find it disadvantageous to disqualify their former lawyer now at the firm, because that would introduce an element of delay into the dispute time for another firm to be hired and brought up to speed and the like. I must say, Pharmaco would prove itself remarkably, perhaps even singularly unique in agreeing to such a thing. I don't know of anybody who would agree to waive that conflict, even with screening in place.
Yeah. Okay.
For what it's worth, the Supreme Court of Virginia, on 3 separate occasions, my understanding, received a recommendation from the state bar to approve of certain limited situations in which conflicts could be cured solely by screening without the requirement of waivers. The Supreme Court of Virginia rejected all 3 of them. So screens alone are interesting, but they don't cure the conflict. You must have conflict waivers to do so.
Right, yes. So screens in Virginia, you can't cure with a unilateral screen.
Correct.
Okay, thank you. All right, let's go on to case 4. Let's assume the same facts as in case 3, except that the former Pharmaco lawyer here had no involvement in the sale of the property for Pharmaco, and she had no occasion to gain access to material information concerning the sale. She did, however, have general supervisory authority over the group of in-house lawyers at the company who did handle property sales, including the sale at issue. And in that role, she had personally been involved in many similar types of matters for Pharmaco. As a result, you conclude that she had at least a general knowledge of the strategies, policies, and personnel at the company. Now, does her new firm still have a conflict? We had about 78%, 4 out of 5 that correctly answered the last question. But now our former lawyer had no personal involvement, but did have general supervisory responsibility and has, as a result of that, general knowledge of strategies, how the company has approached these kinds of issues in the past and the like. So does this change your answer? Does the new firm still have a conflict of interest? Give everyone a chance to respond. I want to remind everyone to make sure to answer each quiz question in order to get CLE credit. And you may know that if you have any kind of technical problem, just enter a note about that in the Q&A. All right, we have 79% still answering yes. Does her new firm have a conflict of interest? Paul, what's your opinion?
Well, and mine and the ABA's, as it turned out, is that no, it does not present a conflict of interest. Referring back to the ABA formal opinion from 1999 referred to in case 3. The fact that a lawyer has represented his former employer in similar types of matters, or that the lawyer had gained a general knowledge of strategies, policies, or personnel of the former employer, isn't sufficient by itself to establish the substantially related factor between a current matter and matters in the legal department at the organization for purposes of Rule 1.9a. General supervisory responsibility, such as that exercised by the head of the legal department, generally is not by itself sufficient to establish that a lawyer represented his former employer in a particular matter, even if it's the same as or substantially related to a matter at the new firm. Instead of looking at Rule 1.9a, look at Rule 1.9b, which applies in situations in which the former in-house lawyer did not personally represent the organization in the same or substantially related matter. There, the lawyer only has a conflict if Pharmaco has interests that are materially adverse to those of the buyer, and it clearly does, and the lawyer acquired confidential information material to the matter. Under the facts of this case, it appears that the former Pharmaco lawyer never gained any material information concerning the sale and only had a general knowledge of the strategies, policies, and personnel of Pharmaco. Now, the ABA formal opinion notes that some courts have continued to consider a general knowledge of the client's organization, practices, and strategy to constitute protected information, but others have rejected that concept, which inconsistency the ABA committee attempts to reconcile by observing that whether the lawyer has protected information depends on the facts and circumstances of each particular case. So the former Pharmaco lawyer and her new firm would have to consider carefully whether, notwithstanding her apparent distance from involvement in the sale, she acquired material information that she would be precluded from using or revealing under Rule 1.9c. Comment 4 describes the competing considerations that flesh out that rule. First, the client previously represented must be reasonably assured that the principle of loyalty to it is not compromised. Second, the rule should not be so broadly cast as to preclude other persons from having a reasonable choice of legal counsel. Third, the rule should not unreasonably hamper lawyers from moving between different employment situations. In this connection, the comment notes that many lawyers practice in firms, that many lawyers to some degree limit their practice to one field or another, and that many move from one association to another several times in their careers. I'm on my 5th stop. If the concept of imputation were applied with unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another, and of the opportunity of clients to change counsel.
Okay.
This sort of playbook information is sometimes called, where you know the client's policies and procedures because you've handled similar matters for it. I suppose the move by the former employer client to seek to disqualify you, which can just about be guaranteed in this situation, is more or less likely to succeed depending upon the amount of time that has passed since you made the move from the company to the outside law firm. Because let's face it, policies and procedures, what issues you stand firm on, what issues you give on, what compromise language you agree on in certain situations, that changes over time. The playbook isn't static. And if this situation arises a month or two after the lawyer has moved and had recently handled a similar matter involving similar issues and applying the same aspects of the client playbook, you may have a better time at persuading the judge to disqualify, even though as an ethical matter, it might not be considered a conflict of interest. If more time has elapsed, it seems to me your motion to disqualify is going to get weaker and weaker.
That makes sense. There are a couple of good questions on this scenario but I'm going to move on to case 5 just because we're short on time, and I will try to provide some answers in the Q&A if I get an opportunity. But let's move on to case 5. You are deputy counsel at a large manufacturing company in Virginia. The senior vice president takes you to lunch one day and tells you that she and her family are planning to purchase a farmhouse and property in an outlying county. She knows that you have a lot of experience as a lawyer with the buying and selling of real estate, local zoning laws, and the like. She asks if you would be willing to help and advise her and her family in the acquisition of the property, and states that she's willing to pay you or reimburse the company for your time providing her and her family with these services. Your employment agreement with the company requires you to devote your professional time to the company, with the exception of pro bono services to the public, and does not permit you to accept any compensation for legal services from any third parties. So the question is, are you permitted to provide the services requested by your CEO nicely at lunch, whether or not he or she reimburses the company for your time? Let's open the poll. And I know some people have had some difficulty getting their answers in. We're providing about a minute because we only have an hour in the program. So just try to get your answer in so that we can get everyone the CLE credit. You're not actually being graded, so if you get the wrong answer, there's no penalty. We have about 30 seconds left in the polling. Running to Google is probably not going to make a difference in the second minute. So let's keep it open a little bit longer here for a few more responses. Let's go ahead and wrap up. And we have about 78, 79 seems to be the magic number today, Paul. We have about 79% of listeners saying that you are not permitted to provide these services. What is the true answer?
The true answer is that no, you may not. This has been well established in Virginia since at least 1993, when Virginia UPL Opinion 167 was issued. It addressed whether in-house counsel of the corporation could provide personal legal services to the CEO and sole shareholder. The UPL committee noted a prior opinion from 1983 to the effect that it would be improper for any attorney employee of the late corporation to assist the corporation in the unauthorized practice of law. The committee stated that since the in-house lawyer is employed by the corporation, the delivery of legal services to the president, owner, or to clients of the corporation would constitute the unauthorized practice of law by the corporation. Now, regardless of whether the president/owner is the alter ego of the corporation is a legal entity separate from the individual. So the committee took the view that the attorney could only render legal services to the CEO if the attorney was a member of the bar who had a separate practice from his employment with the corporation. But according to the rules of our hypothetical and of this opinion, his employment agreement required him to work exclusively for the corporation except for certain pro bono work. This should be distinguished from situations in which the in-house counsel provides legal services to a client in circumstances other than under the auspices of the corporation.
Yeah. Okay.
And that would be the case if the lawyer maintained a separate practice.
Okay, we're moving on to case 6, making good progress here. A company headquartered in Virginia wishes to hire a member of the Virginia State Bar as its general counsel. As general counsel, this lawyer will be exposed to and will become familiar with the company's trade secrets and other confidential proprietary information. That information could cause substantial harm to the company if it was disclosed to a competitor. The company requires that the lawyer enter into a non-competition and confidentiality agreement that prohibits the lawyer from working as a competitor's in-house counsel for 1 year following termination of his employment with the company. May the lawyer enter into the agreement, the non-competition and confidentiality agreement? We're opening the question. We'll give about a minute for responses. May the lawyer enter into the non-comp and confidentiality agreement? Thirty seconds left for our polling. So let's get the answers in. And we're approaching the end here. Rush in your answers. No penalty for a wrong answer. May the lawyer enter into a non-compete and confidentiality agreement? Let's close it and see the results. So this one much closer, Paul. It is about 50-50. With a slight edge towards no, the lawyer may not enter into the agreement. What is the answer?
It's like we evenly split the house.
Mm-hmm.
The answer is an emphatic no. This is similar to the fact situation in a Virginia Legal Ethics Opinion number 1615. The non-compete and confidentiality agreement that was discussed in the LAO was not part of the employment agreement between the lawyer and the company. That non-compete agreement expressly limited or permitted the lawyer to serve as outside counsel to a competitor without restriction, so long as he didn't disclose the company's confidential proprietary information. Now, the relevant rule is 5.6. It says the lawyer shall not participate in offering or making a partnership or employment agreement that restricts the right of a lawyer to practice after termination, except an agreement concerning benefits on retirement. Now, the State Bar Committee issuing the opinion found that the non-compete provisions of the agreement were improper. The fact that the non-compete was separate from the employment agreement was not material to the analysis. They were going to apparently took the position the lawyer did that and his employer that as it was not part of an employment agreement, it didn't literally fit the prohibition in Rule 5.6. As I say, the committee didn't fall for that. The committee noted that as an in-house lawyer is bound by the confidentiality requirements of Rule 1.6, as would be any outside lawyer, confidentiality portions of the proposed agreement were superfluous in any event. Now, the rules of professional conduct don't bind a corporation or other business entity that is not a law firm, but they do bind both the lawyer who is asked or required to sign the non-compete agreement and any officer or employee of the company who is a lawyer and who takes part in the decision to require such a non-compete agreement from the lawyer in the first place. That's a two-edged sword.
Yeah. All right. Let us move on to case 7. You are in-house counsel for the company, and an employee comes to your office and complains of a hostile work environment because of repeated sexually offensive remarks by a coworker in the workplace. When asked on numerous occasions, the coworker has denied the other worker's claims, and management asks you for advice. You research the applicable law and conclude that one-party consent recording is legal in the jurisdiction where both the employees are and where you are. So the question here is, could you ethically recommend that the complaining worker be wired to record her coworker's remarks? Who thinks the answer is yes? Can you ethically recommend in a one-party consent state that the worker hook up a wire and record her coworker's remarks? Don't forget to make sure to answer every question. You're not being graded. Doesn't matter whether your answer is yes or no, but to record that you voted for CLE credit. We have about 20 seconds left in the polling. We'll see if we are back in the 50% land or in the no-brainer 4 out of 5 land. We're about to close the poll. And we're back in close to 50-50. We about 55% say no, 45% say yes. Dr. Saunders, what do you say?
The correct answer is yes, although I can understand why people initially would be inclined to say no.
Yeah, I was going to say, I almost feel like I've been practicing long enough that maybe the answer was different when I first started practicing. But why don't you go ahead and explain?
The answer has been evolving for some time now. Fact is that it's been a subject of debate for 20 plus years, dating back to a Supreme Court decision in a disciplinary matter against a lawyer named Gunter in 1989. Gunter had represented a husband in a divorce and advised the husband to install a recording device on the telephone in the marital home to obtain evidence that his wife was having an affair. When she discovered the recording had occurred, Gunter was indicted for conspiracy to violate the wiretapping statute. The jury acquitted him, but then he was brought up on disciplinary charges by the bar. The Supreme Court ruled that the recordation by a lawyer or pursuant to his authorization of third-party telephone conversations to which the lawyer was not a party was conduct involving fraud, dishonesty, or deceit in violation of the rules then, which were called the Code of Professional Responsibility. The Virginia State Bar argued that the recording had violated the wiretapping laws, even though Gunter had been acquitted of conspiracy. The bar stressed that more is expected of a lawyer than merely refraining from criminal conduct, and the Supreme Court agreed. Love this language. It shows up in a lot of opinions. The lowest common denominator binding lawyers and laymen alike is the statute and common law. A higher standard is imposed on lawyers by the rules, many parts of which proscribe conduct that would be lawful if done by laymen. It follows that conduct may be unethical, measured by the requirements of the Code of Professional Responsibility, now the Rules of Professional Conduct, even if it isn't unlawful. So it's immaterial whether the conduct that was complained of in that case violated the wiretapping laws, and the Supreme Court expressly refrained from deciding that question. Now, there followed the Gunter decision a series of ethics opinions that culminated in a blanket ban on lawyers engaging or advising their clients to engage in the recordation of conversations in which they were participants. One-party consent recordings, as they're known, are legal under Virginia law. That's Virginia Code Section 19.262B2. But as a result of legal ethics opinions 1738 and 1765, the pendulum swung back. The Legal Ethics Committee of the State Bar recognized at least 3 circumstances in which undisclosed recording would be ethical: housing discrimination investigations, criminal investigations, and situations involving actual or threatened criminal activity where the recording lawyer was the victim or intended victim. The committee also recognized there might be other fact situations in which it might be ethical for a lawyer or her agent to lawfully record a telephone conversation. Didn't stop there. In 2010, the committee issued LAO 1802, recognizing 2 more exceptions to the no wiretapping rule. In the first situation, an adult victim of childhood sexual abuse contacted a lawyer about pursuing a civil claim against her father, the abuser. The father had freely admitted the sexual abuse in prior conversations with his daughter, the victim, and there was no corroborating evidence of the abuse other than the victim's testimony. The attorney suggested that the client tape record her conversations with her father. The committee balanced the lawyer's duty under Rule 1.3 to diligently pursue the client's legal objectives and Rule 1.4 to keep his client informed against concerns about conduct involving deceit, dishonesty, and the like that informed the earlier blanket prohibition on one-party consent recording. Clients consult with lawyers for solutions to legal problems and expect lawyers to suggest the means within the bounds of the law and the rules by which to achieve those objectives. Your lawyer isn't violating or attempting to violate the rules through the actions of the client by advising the client that she may record conversations. Rather, lawyer is advising the client of a legal course of conduct, which may or may not be acted upon by the client. In so doing, the lawyer is discharging her ethical obligation to advise the client of lawful means by which to achieve the client's lawful objectives. Second situation was the fact situation for this hypothetical. The committee noted in both of those examples, proving hostile sexual work environment or sexual abuse of a minor, the committee faces situations in which the client has asked the lawyer for his or her opinion on how to address the client's legal problem. The proposed undisclosed recording is not only lawful, but could very well be the only means by which the client may obtain relevant information. Nothing that the lawyer suggested or recommended violated the legal rights of the person whose statements are to be recorded. So the committee seems content at this point, rather than establishing a bright line standard that applies in all cases, to address the permissibility of these recordings on an ad hoc case-by-case basis, which leaves us all waiting for the next shoe to drop. And we don't want to be the one who decides to push the envelope only to have the bar or the disciplinary authorities decide that we've gone too far and they're not willing to extend the permissibility of such recordings to include the situation in which we're acting.
Yeah. It occurs to me that there's also a real analogy here to the bar's treatment, various bars of the no contact rule, and whether lawyers can advise their clients to contact another party who the client knows but is represented by counsel. In a similar way, views have evolved in various bars on that, not so much in Virginia, on that same rationale that basically to not be able to advise your client of what they have a perfect legal right to do is handcuffing the lawyer and preventing them from giving competent advice to their client. But we don't have a lot of time, so let's move on and try to get at least one more case in today, case 8. Your legal secretary resigned in order to go back to law school, and back to school. Your company advertises for a replacement and is contacted by a legal secretary who works at a law firm in town. She has a strong resume and is equally impressive in the job interview. You make an employment offer and she accepts. Do you have any duty to check for conflicts of interest before she comes to work for you at the company? So we're going to open up the question. Do you have a duty to check for conflicts of interest for a legal assistant who comes from a different firm to work for you at your firm? Or excuse me, at your company, at the law firm, the legal department of your company? We have about 30 seconds left for polling on this question. Do you have any duty to check for conflicts of interest before the legal assistant comes to work for you at the company? All right, closing the poll. 59% say yes, you do have a duty to check conflicts for a legal assistant coming from a law firm. And 41% say no. Paul, is there a clear answer on this one in Virginia or elsewhere?
Yeah, you don't generally find it addressed in Virginia legal ethics opinions. The best expression of it, as it happens, is from a Los Angeles County Bar Ethics Committee opinion in 2011. Non-lawyer employees, including secretaries, law clerks, and investigators, are not subject to the rules of professional conduct. Only lawyers and law firms are. That includes the confidentiality obligations imposed on lawyers under those rules, especially the confidentiality obligations under Rule 1.6 and 1.9. But lawyers have an ethical duty to supervise their non-lawyer employees and are accountable for their conduct, especially when it involves lawyer-client confidentiality. Under Rule 5.3, the hiring firm's lawyers have a duty to conduct reasonable inquiry into the possibility that a prospective employee has been exposed to confidential information in a prior employment regarding a matter material to the current employment. Suppose a newly hired secretary previously worked for a lawyer representing plaintiff in pending litigation in which her firm represents a defendant. The committee stressed that the hiring firm's inquiry should determine whether the employee was likely to have been exposed in her prior employment to confidential information that must be shielded from the hiring firm. So they should not, in any event, probe the substance of that information. If the hiring firm discovers that the employee has been exposed to that confidential information, it has two options. First is to obtain consent from the former employer. Second, if consent isn't available, the hiring firm can satisfy its obligation by imposing an obligation on the new hire not to disclose confidential information acquired during his or her prior employment, and by screening him or her from the matter in common between the prior employer and the current firm. So that's a case in which a potential issue, I'm not sure I call it a conflict, but it's the next best thing to a conflict. It can be cured by screening without necessarily getting a consent from the, in this case, the prior employer.
Okay. We are almost out of time, but let's see if we can sneak in one last question. After law school, let's go to case 9. We may not be able to do the full analysis here, Paul, but let's see if we can answer it. After law school, you joined a Virginia law firm and worked there for 5 years. You decided to make a job switch and just started working with the in-house counsel's office of Alpha Corp, handling finance and other transactional matters. In your first week there, you encounter a woman you haven't seen since both of you graduated from college. She's only been at the company for 7 years, but she's done quite well and recently was promoted to the youngest SVP in the company's history. You always liked her and wanted to ask her out in college, but you didn't because she was engaged to your best friend. As it turns out, their relationship ended years ago and she isn't seeing anybody. The two of you hit it off immediately and start dating. And then within weeks, you realize you may have a future together. Apart from complying with company rules regarding dating or marital relationships, are there any ethical issues that you should consider before your relationship gets more serious? Let's open the poll. Are there any ethical issues in your wanting to date the senior vice president of the company you work for as an in-house counsel? And like I say, on this one, we'll give the answer, but not be able to do the full analysis of the answer for everyone. But all of that information is provided in the materials that you have. So we have a few more seconds on this last polling question on relationships. And we closed the poll. 75% say that there are some ethical issues. Paul, is that correct?
That is correct. In this case, I say the answer is yes. Model Rule 1.8J provides a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. Now, initial reaction, certainly mine, was that shouldn't be an obstacle to your relationship with her because your client is the company. She isn't the client. Hold on, take a look at comment 22 to the model rule. When a client is an organization, the prohibition in 1.8J prohibits a lawyer for the organization, whether inside or outside counsel, from having a sexual relationship with a constituent of the organization who supervises, directs, or regularly consults with that lawyer concerning the organization's legal matters.
Yep. let me just observe that if I can, because we are out of time, Paul, but when you look to this on a state-to-state basis, look both to, in some states, this comment 22 in model rule in the matching rule 1.8J, which is where it's addressed in Virginia still. But in many other states have adopted a model rule 1.19 that the ABA issued 30 years ago, including North Carolina, that more specifically address this scenario. But we are out of time. We want to thank everyone for attending today. And if you have any questions, your questions on the chat have been Q&A have been very interesting. If you have any other questions, just feel free to reach out to me or Paul. You're now headed into your break, and after the break, you'll hear from Kevin Pomfret, who will discuss all businesses are now data businesses and what that means from a legal standpoint. That'll begin at 2:10. So thank you.
Thank you. Have a good day.